Am I right about that, Alex?
Yes, we can get started.
Right. Well, I would like to welcome you all to this panel where we are going to be discussing the waters of the United States, the new waters of the United States rule, which we always have a new rule coming. We don't necessarily know what rule we have or which states it's applicable in. And it seems to be a perennial moving target. And we're going to look at where that stands today, where it's headed, and what it might mean, not just for the idea of dredge and fill permits, which is what gets a lot of attention, but really what's the what does it really portend for water management and water stewardship? Because water is dynamic, and water law needs to accommodate that. And while the Clean Water Act is not what we normally think of when we think of pure water law, it certainly it has to keep step. For those of you who haven't spent much time in this area, let me introduce myself first. I'm Mark Davis, and I'll be your tour guide here. I teach water law, amongst other things, here at Tulane Law School, and I run the Institute on Water Resources Law and Policy. And the history of federal water legislation actually goes back a long time. The first real efforts came in 1890 in the Rivers and Harbors Act, and then which got upgraded in the Rivers and Harbors Act of 1899, which that's really, you still get a Rivers and Harbors Act permit when you go to the Corps for your Clean Water Act permit, because it covers some of the same things, but it does not have all of the same exclusions. It's still important. And so it's also important to make sure that when you're thinking about the jurisdiction of one federal law, you're thinking in terms of what else it may reach. Needless to say, we found that in a federal system where states have responsibilities for managing the waters within their borders, but often doing things to waters that affect their downstream neighbors, that the approach that we had been using wasn't working. And then we began modifying federal law with really the Federal Water Pollution Control Act in 1948. And that grew up in 1972 into what we now think of as the Clean Water Act. And the Clean Water Act itself was a pretty darn amazing thing. It was, bipartisan in its, in its support. Its purpose was very simple, very simple. It said to restore and maintain the chemical, physical, and biological integrity of the nation's waters. Now, it didn't say waters of the United States. It didn't say navigable waters. It said the nation's waters. And then it went on, when you start thinking about, well, how it regulates pollution and the discharge of dredge material and the like into the navigable waters. And that's where navigability and the notion of waters of the United States come together. And it has been a ride since then. We have seen agency disagreements and agreements and jurisprudence that expanded the notion of what should be included. Then we went into an era of retrenchment, and we're still firmly in that. All that time, the definition in the statute has not changed. What has changed is interpretations, and, if you will, the conventions the courts are using to discern what Congress meant and didn't mean. That is why it's the source of so much confusion, because it's a bit like playing a game where the refs keep getting a new rule book, and you wonder, well, what's the purpose of the game? Is it just to apply rules or to effectively have an outcome? So we're really blessed today with to have two panelists with us who have spent far more time than their friends and family wish they had thinking about some of this stuff, and not just thinking about it, doing things about it. Larry Liebesman, who is now a senior advisor with Dawson Associates in Washington, D.C., which, in the estimation of many, is perhaps the premier governmental, not really lobbying, but more of a governmental services firm that deals with all things water in Washington, D.C. He spent, was it 11 years at Justice?
11 years, yep, you got it.
Where he worked these issues. He's written and co-authored, briefs in some of the most significant cases in the field. And he does more than water. He does endangered species and other things. But you won't find anybody who comes close to his experience, with the possible exception of Jim Murphy. Jim Murphy comes to us from the National Wildlife Federation, where he is he's the director of legal advocacy. Am I still correct yet? There's been no change since we last chatted.
Yep, that's right.
He coordinates, their advocacy across a number of platforms, energy and clean water. He also works with the Vermont Law School's Environmental Advocacy Clinic. So he not only thinks about, he works in the field. So between these two people, I think you're going to have a real opportunity to improve the level of your confusion. I'm not promising that we can resolve it. I'm going to ask, Larry to lead off just with your impressions of how in the world did we get where we are today?
Sure.
And then we're going to talk later about, what's in the cards, since we have new rules, we have litigation, and even elections. Larry, take it away.
Sure. Yeah, thank you for that great introduction. Appreciate being on today. Yeah, I want to sort of give you my sense of an overview of what I think are the key issues that have emerged or are likely to continue to emerge on this issue. Waters has been a big part of my career, as you pointed out. My days back at the Justice Department was there when Riverside Bayview Homes was decided, and certainly in private practice, working with clients. And so when you look at what Congress is trying to do, they send out very broad goals in Section 101A of the Act in 1972 in terms of protecting and preserving the chemical, physical, and biological integrity of the nation's waters, as you say. So you've got Section 101A. Then you look at Section 101B, which says nothing in the statute basically undermines the ability or the right of states to plan and preserve their water resources. I'm paraphrasing it, of course. So Congress set up a tension between these two sections, and that has been in many ways the root of where we are today. This tension has resulted in trying to come up with a definition that defines the limits of federal jurisdiction for the purposes of the Act and where the states come in and how they work together, this sort of cooperative federalism. Along with that, you have a statute that created a number of permit programs. Certainly Section 404 is the program that we're all familiar with, the dredge and fill permit program, focusing primarily on impacts to wetlands. Then, of course, you got the NPDES program, Section 402, which has been delegated, I believe, up to 47 states around the country. In 404, it's been primarily the Corps' responsibility, and now we've got Florida, the third state, to assume that program. So you've got these broad programs. Then you've got Section 311, which is the oil spill program, again, another permit program. Overlaying much of this is Section 401, the State Water Quality Certification Program, again, the role of the states. So you've got this dynamic program that Congress envisioned to achieve these water quality goals, but to preserve and protect the rights of the states. So given that tension, what we've seen is the Corps, and of course, you've got a division of responsibility between the Corps and EPA. EPA's the final say in jurisdiction, Corps primary responsibility, particularly in the dredge and fill permit program on 404 permitting, which is the bulk of the wetlands permitting process out there. So the Corps, of course, then began to initially expand jurisdiction from a regulatory standpoint to go beyond traditionally navigable waters and wetlands that are abutting or adjacent to those waters up the landscape, issuing regulations in the 70s and certainly into the 80s that basically said adjacent wetlands can, and the tributary definition can basically go up the landscape to intermittent and indirect waters, the so-called headwater areas and wetlands adjacent to those, to achieve the goals of the Act. And then you, as you fast forward to that process, that regulation's there, and then you go to Riverside Bayview Homes, which was the first time the Supreme Court really began to tackle this issue broadly, but dealing with a wetland that essentially abutted an open water system. So the court came out with some very strong language, I think is certainly worthy noting, about water moving in hydrologic cycles that are circles, that essentially the source of the water does not have to be the adjacent navigable water itself, but it can be the wetland, because they work together to achieve water quality goals in terms of the water quality of that adjacent navigable water. But it made it very clear that we're not sort of reaching waters, they're not abutted or immediately integrated with that adjacent traditionally navigable water. As you said, and just sort of filling that gap a little bit, when you look at the expansion from the Rivers and Harbors Act that dealt with waters that were essentially flowing in commerce. That was the limitation of the Waters and Harbors Act. So certainly Congress, in enacting the Water Pollution Control Act, took the word navigable waters from the prior Rivers and Harbors Act approach. But again, expanding that to deal with water quality and this comprehensive regulatory permit program. So Riverside Bayview Homes said, well, you know, the ecological goals and focuses of the Act are very important, and the Corps has jurisdiction to reach adjacent wetlands to achieve those goals. But made it very clear that we're not going beyond that. We're not going up the landscape to see how far jurisdiction really goes. That'll be for another day. So of course, then you get fast forward, and most courts during, I would say during the 80s, I was at Justice again when Riverside Bayview Homes came down, would largely defer to the Corps' interpretation. A fairly broad expansion of jurisdiction. The regulation talked about the effect on commerce, and that's another factor as well. So because the legislative history of the Act basically said the reach of jurisdiction goes to the first extent permitted under the Commerce Clause of the Constitution. So you've got the Commerce Clause issues that tie into that define the limit of federal authority generally, and that's been broadly interpreted, as you know, not only in the water pollution context, but in so many other statutes, you know, civil rights, for example. But that limitation was built into the regs. So then you fast forward, you know, with so many court and administrative interpretations that defer to the Corps' expertise, and it's sort of sweeping in these large areas that are up the landscape that provide ecological benefits to even intermittent and ephemeral streams that eventually reach these flowing traditionally navigable waters. So then you come up to Swank. Okay, Swank dealt with an interesting and somewhat unique fact pattern of not a wetland, but an abandoned sand and gravel pit outside Chicago that was basically isolated. And there the question was whether jurisdiction under the Clean Water Act and the Commerce Clause would reach an abandoned sand and gravel pit because of what is known as the migratory bird rule, what we like to call it the reasonable bird rule, that migratory birds traveling in interstate commerce would land there, and that would provide sort of a habitat, an ecological benefit for the aquatic ecosystem that provided support for these migratory birds. But again, and that was also tied to the migratory bird rule and international convention. So the core sort of jurisdiction on the migratory bird rule. So then, of course, that was challenged by the county and saying, you know, you shouldn't reach the non-wetland abandoned pit on the basis of the migratory bird rule, which, by the way, was never even in the actual 1986 regulation, but only in the preamble of the regulation. And so fast forward, you've got Swank in a 5-4 decision in 2001, written by Justice Rehnquist. And Justice Rehnquist basically said that migratory bird rule, writing for the majority, went too far. You know, that by determining that it could be swept under the Commerce Clause, that would involve the court in addressing constitutional issues, which we tried to avoid. So the way to avoid constitutional issues is to say the Corps does not have authority to regulate an abandoned sand and gravel pit under the Clean Water Act. Justice Stevens, of course, in dissent, a very interesting dissent, basically tackled the Commerce Clause issue and said that should not be a limitation, and said, no, well, you should defer to the Corps' ecological judgment, that sweeping in that abandoned pit on the basis of migratory bird use falls within the broad scope of authority under the Clean Water Act, and it would not violate the Constitution, the Commerce Clause at all. But that was, again, a very strong dissent. So, what the other interesting aspect of it, for the first time, we see the Supreme Court using the word significant nexus, because the court dove back into the legislative history of the Clean Water Act, and the Riverside Bayview Homes said that it was the significant nexus in Riverside Bayview Homes that informed the court about the connection between that wetland and the adjacent and abutting navigable water. So for the first time, the term significant nexus, which does not appear in the statute, nowhere in the Clean Water Act at all, rears its ugly head. It basically is birth, it is born. And so we've got SWANK. And so then following SWANK, of course, is an effort by the Corps and EPA to make some sense about what that means. And they come out with guidance and they start a rulemaking process that sort of falls flat. Again, when you're dealing with an issue like this that cross-cuts so many broad interest groups, you're talking about the environmental community, states, local governments, property owner, public agencies, infrastructure projects, to get them all together to come into an agreement about what makes sense to achieve the goals of the act was a virtual impossibility. And I hate to say it, it's sort of the way it is today in many ways. So then you fast forward to Rapanos. Okay, so here you got Rapanos, and you've got a unique set of facts that are not the extreme of Riverside Bayview Homes, but not the isolated pit that you had in SWANK, but basically you've got wetlands adjacent to drainage ditches and intermittent ephemeral waters in Michigan that eventually lead to a traditionally navigable water. And the question is, does jurisdiction go up the landscape to reach these adjacent wetlands? And so what happened in SWANK was that, of course, the Corps sort of jurisdiction, drawing upon their interpretation of Corps jurisdiction and the ecological benefits provided by these adjacent wetlands, and asserted jurisdiction. Well, and when it gets up to the Supreme Court, and a very confusing and fragmented decision, I was involved in writing an amicus brief, actually, in both SWANK and Rapanos, we had a very confusing and fractured ruling that is sort of again, perpetuates the confusion that we're all living with today. And so there, Justice Scalia, in his sort of originalist and literalist interpretation of statutory language, lopped onto the concept of navigable waters and flowing streams, and basically said the test is really one of surface hydrologic connection, and that a wetland had to be basically abutting a flowing stream. It can be even an intermittent stream, doesn't have to be traditional navigable water, but it must be abutting, so you really can't tell the difference between where the water ends and the land begins. It's all sort of connected. And so, and he analyzed the legislative history and SWANK, and basically said that's the only sense that's the only interpretation, the way he sees it, that makes sense. It's got to be based upon a hydrologic connection in some fashion. Talked quite a bit about Section 101B and the rights of states and land, and property owners, and the division of responsibility between the federal government. That the federal government is not plenary, that sweeping in all these areas would basically be limitless. You really wouldn't know where federal jurisdiction ends. So that's why, because in his view of the law, navigability was the key language. And so, but then you've got Justice Kennedy. Justice Kennedy agrees with the judgment, but not on a totally different theory. So in other words, they're overturning the Sixth Circuit's analysis, upholding the Corps, but Justice Kennedy says that went too far. And therefore, the significant nexus, I think he says, I'm going to explain what it means. It's reared its head in SWANK. And now the way I see it is significant nexus requires looking at whether the wetland in combination with similar situated wetlands in the landscape significantly affects the water quality of the traditionally navigable water. And that involves analyzing on a fact-specific basis, site-specific basis, whether certain factors are met. And they may be an ordinary high water mark, it may not be, but that analysis has to be done on a case-by-case basis. It takes very strong issue with Justice Scalia's analysis. So Justice Scalia would basically write out the ecological goals of the Clean Water Act to focus only on flow, only on surface navigability, and not on the ecological goals of the statute, which he thinks significant nexus would achieve. But the limits, and then basically says, do some rulemaking. And he also takes issue with Justice Stevens. He said, Justice Stevens' view of Corps' plenary authority in the act simply goes too far and writes out the limitations that Congress intended under the act. And so you've had two divergent opinions that have come out of it. And so then you sort of fast forward. I'm sorry if I'm getting into too much detail on the history of this, but I think it's important to understand how we got here and where we came from. And then we've got so many different courts around the country trying to figure out how a fractured opinion under the Marx analysis, which tries to make sense of where you've got fractured opinions and you can't come up with a consensus. And so that then resulted in litigation in district and courts of appeals around the country, a good number of which have held that the Kennedy significant nexus test should be the controlling test. That's the one that is the least test that rolls back federal jurisdiction the least and reaches the goals of the act. And then a number of courts, that I think the First Circuit and a few others have said, you can use either test. You can use your test. And of course, but I think the majority of the courts that have addressed it, such as the Fourth and the Seventh and the Ninth Circuits, have pretty much deferred to the Kennedy test as the controlling test. And of course, a number of circuits haven't even addressed the issue as well. And so here you have fast forward, utter confusion. And so coming out of Rapanos, the agency said, what are we going to do now? Let's do a rule. Now, let's come some guidance. We can figure, let's see how things develop. So they come out with a guidance document that is designed to capture both the Kennedy and the Rapanos and the Scalia tests through a site-specific analysis, drawing distinctions between relatively permanent waters and wetlands that are abutting them, and the significant nexus test for wetlands that are adjacent to non-relatively permanent waters, intermittent and ephemeral waters, and requiring a site-specific analysis, kind of data that has to be gathered. And they issued a fairly extensive guidebook, technical analysis, case-by-case determinations for significant nexus. And that basically was the regulatory regime for a good number of years, as we tried to make sense of these competing opinions. But of course, that generated a lot of reaction. And the agency said, we need clear guidance. The regulatory community says, we don't know what to do. What do we do? How do we get a permit? What's the limit? It's creating confusion. There were a lot of anecdotes of how this was really affecting a broad range of interest groups around the country. So that sort of generated the need to move to a new rulemaking. And that led to the Obama 2015 rule, which really deferred largely to the Kennedy significant nexus test as the proper test that captures the true meaning and purpose of the Clean Water Act, but in a way that does not do injustice to the rights of states. And so that came out in 2015. As one can imagine, the development interests and the so-called red states, the Republican-leaning states, sue. And so they sue and they win in a number of big decisions that were very critical of the Obama rule and saying basically went too far. The rulemaking record was not sufficient. It captured and brought in through the aggregation theory, even isolated wetlands that in many ways arguably were excluded under SWANC, but brought them in under the aggregating these kinds of waters and wetlands that are a distance away from traditional navigable waters. And so here that gets struck down, although it remains in effect in some 22 states. So it's enjoined in, I think, some 26 states, remains in effect in 22 states. So again, confusion reigns. as the Trump administration comes into play in 2017. So, Trump comes in and says, we're going to come up with a rule that clarifies this mess, so to speak. So he directs through an executive order the agencies to develop a rule that gives due deference to the Scalia test. And what comes out of that is it does in two steps. We're going to revoke the Obama rule, and then we're going to come out with our new rule. And so we go through an extensive rulemaking process that leads to the 2020 rule that is designed to focus on the Scalia test on flow, but has a few quirks in it, that tries to capture some of the Kennedy rationale on water quality, but says if focus on flow from a wetland to a traditional navigable water will capture the water quality goals of Justice Kennedy in many ways, and develops that rationale for that, but it's still focused very, very, very heavily on flow, but excludes isolated and ephemeral waters, many headwater areas that are intermittent in terms of the flow. It doesn't have a relatively permanent flow. It's not regulated, but doesn't come out with a really clear definition of how much flow you really need. Using a rolling 3-year average of rainfall, which is hard to discern, but defers to the agencies to come up with criteria. Okay, so that comes into effect in June of 2020. Alas, we have an election that everybody agreed on, right? So anyway, so President Biden comes in, and it's designed to come in and try to restore a lot of the ecological goals of the Obama administration. And certainly, WOTUS was very high on his list. So he issues an executive order to require the agencies to come up with an approach that creates a durable rule that addresses the goals of the Clean Water Act and tries to bring all the stakeholders to the table. Let's come up with something that works. And so he asked the Justice Department to seek a stay of the Trump rule, let it stay in effect while we go through this rulemaking process, a 2-step process. First, we'll formally revoke the Trump rule, and then we'll embark on this lengthy rulemaking process on our own. And so, hunky-dory, we'll have plenty of time. So alas, courts in both Arizona and New Mexico, first Arizona, last year vacates the Trump rule and rejects the government's argument that it should be stayed, and cites, at a preliminary stage, that the Trump rule is leaving a lot of wetlands unprotected, especially out west, where you're dealing with very arid environments. And that was followed by a suit brought by the Navajo tribe suits were actually brought both by tribes in both states that came out with the same rationale. But interestingly, the question is whether that vacature of the rule applies nationally or only in those states, in the Ninth Circuit. So that's sort of and the 10th Circuit would be, for I believe, in New Mexico. So in any event, the issue is, does it apply nationally or not? Well, EPA and the court take a position. It applies nationally. It's vacated. We're now going to go back to the pre-2015 regime, which is the Rapanos guidance of 2008 that tries to capture both. And so we're going to treat it as basically enjoined nationally, despite the fact that a number of courts have treated the vacature as not being nationally in scope. But be that as it may, that's how EPA and the Justice Department and the court are treating it through justice. So that's sort of fast forward to where we are right now in this crazy morass. Where we are right now, frankly, is a proposed rulemaking process. Right now, EPA and the Corps have a rule out there, proposal to formally reinstate the pre-2015 regulatory regime as a first step, and then move into a second step, which would be a more formal rulemaking process. And so that's underway. Alas, we have SACIT. Okay, so we've got the Ninth Circuit comes in and adopts the Kennedy test, the significant nexus test. And the SACITs, who are homeowners that own a lot near Priest Lake, Idaho, that's separated from Priest Lake by a number of homes, a number of roads, a distance, but of which the Corps had asserted jurisdiction based upon the ecological interface between that wetland and the lake. The Ninth Circuit upheld jurisdiction on the basis of the significant nexus. So now the court has taken the case, and the court is asked the question of whether the Ninth Circuit, the significant nexus test is the proper test for determining whether a wetland is a water of the United States. And so that is now in front of the court. A briefing is underway. It will probably be argued in the fall, and probably, I suspect, a decision sometime in 2013. So I guess right now is, where's the court going to come down? What are the factors that are going to be considered? Is this court being, more conservative with a 60 majority, more likely to defer to Scalia? Is the court going to try to carve out a middle ground? Another interesting wrinkle is the Maui case that came down last year that dealt with a discharge, from into surface waters of a particular pollutant that travels through groundwater out in Hawaii to reach surface waters, whether that's a regulated discharge of a pollutant into a water of the U.S. based upon what is called as a functional equivalent test of a direct discharge. And so there, Justice Breyer cobbled together a majority of 5, including Chief Justice Roberts and Kavanaugh, to says, yes, it's regulated, and pointed to Scalia. Scalia didn't talk about direct discharges. He just talked about discharges. And so, and of course, the 4 justices went the other way, took a more conservative approach and said that the term discharge does not go that far. But the question is, will that happen here? Will Breyer will not be around? Will Justice Jackson, assuming she's confirmed, be able to step into his shoes and try to carve out a more reasonable test that is clearer and captures the meaning of the act? Or will there be more of a lockstep deference to the Scalia approach? So there are a lot of open questions. And of course, everybody's waiting with bated breath to see where this comes down. Will we finally have a durable rule? Where will the agencies be? Are they going to continue with the rulemaking process or not, or wait for the Supreme Court to chime in? So that's sort of my landscape tour of WOTUS. I hope I captured everything, Mark, but be as it may. Anyway, that's it.
Well, I'm still confused, Larry, but I don't think that anyone on this earth has the power to clarify for me. But I'm going to give Jim a chance, because obviously this is a topic that, quite frankly, goes to the heart of a lot of the advocacy and programming that National Wildlife Federation has had for years. And I don't, if I may, just by way of introduction, for those of you who've not really dealt much with the National Wildlife Federation, their interests are in more than just conservation of critters for their own good. I mean, many of its members through the years have been hunters, fishers, boaters, and Larry mentioned the migratory bird rule, and there's even a migratory bird treaty. Why would that have been so important, particularly for Commerce Clause-based legislation? It's because birds are big business. Not just today's hunters and the like, bird watchers, but a century ago, the plumage trade was staggeringly large, and that's why we actually have a migratory bird treaty, is that we are wiping out migratory birds. And while we can talk about accommodating the independent jurisdiction of states, it was other countries who were worried about what we were doing, not only to our birds, but theirs. And since birds tend not to respect boundaries, to protect them does require at least a coordinated national effort. And the migratory bird rule reflected a federal, an extension of federal protection to their habitat. And so, in case you're just wondering, where birds fit in, birds are really cool, and birds are really important. And thank you for letting me say that, Jim.
Yeah, thank you, Mark, and thank you, Alex, and all the students who helped organize this. I'm really happy to be here, and thanks, Larry, for a very comprehensive overview of what's been, I think, one of the most kind of fragmented legal landscapes, certainly in environmental law and maybe in law in general. Yeah, I kind of started my career in interview after the laser focus on the waters of the United States issue, commonly referred to as WOTUS, which I just found out today is not a word you can use on Wordle. But yeah, I've been doing a lot of climate work in the last 10 years and kind of keeping a finger in this as my colleague, Jan Goldman Carter, largely kind of took the reins for National Wildlife Federation. I've stepped back into it now that she's retired and spending time with her grandkids. And it's amazing how little the landscape and the situation has changed. I mean, I've definitely kept up with it, but yeah, Swank was 21 years ago, and Rapanos was 16 years ago, and we're essentially at the exact same regulatory point we were, assuming that the vacatur of the Trump rule applies nationally. And as Larry pointed out, the Biden rule is really just going to, the phase one is essentially going to take us back to where we were, after Rapanos and after the two guidances from Rapanos. With the idea that it will hopefully come in with a phase two rule that provides more durable clarity. And of course, as Larry also said, when that roadmap was laid out by the Biden administration, the Supreme Court hadn't yet taken up Sackett. So now you've got Sackett kind of lingering over this process, and it could require another major course correction by the agency. And also, there's a question too of, does the rulemaking in Sackett also influence the court? One thing, Larry was extremely comprehensive, but one thing that he did not mention was in Rapanos, Chief Justice Roberts had a kind of short concurrence stating that, if the agency was doing something on this, it might provide the court a reason to look to the agency to solve the problem. And it took a while for the agency to get there, and then politics has played a big role in the agency's ability, I think, to really do a laser focus. The Clean Water Rule came out in 2015. It had some legal problems, that I think could have been fixed by an agency that was committed to the course the Clean Water Rule came on. But then, of course, the Trump administration went in a very different direction. Now the Biden administration is kind of left to clean up the mess. And another thing that is lingering out there is really the inaction of Congress. One thing that Congress defined navigable waters very broadly as waters of the United States. I think kind of creating a little tension in of itself. The court latched on to particularly in Swank. What does navigable mean, and also what does navigable mean through the lens of the history of water regulation, which really until the Clean Water Act was more focused on navigability. But with the Clean Water Act's broad ecological goals, a narrow focus on navigability essentially makes those goals impossible to achieve. So it was recognized in Riverside Bayview, and acknowledged in both Swank and Rapanos, even by the justices who had a more restrictive view of waters in the United States, that Congress did mean something more than navigability. So Congress has also neglected to step into the picture and correct things. And I think the failures there, and I think the failures with the administration are, largely, the swing of politics, and also perhaps a late start. But put the court in a difficult position. The court is probably the branch that's least least well equipped to settle these questions. Because I think at the heart of the Clean Water Act is this goal of restoring and maintaining the chemical, physiological, and biological integrity of waters. And as an organization focused on not just protecting wildlife, but also really protecting the communities that rely on natural resources, you have to really look comprehensively at the aquatic ecosystem to achieve those goals and to have clean water and to have water systems that work. A lot of the waters that are at risk here are the intermittent and ephemeral streams, the wetlands, the so-called isolated wetlands, perform an enormous amount of functions that are absolutely critical to the health of aquatic ecosystems in general, including our largest rivers, lakes, estuaries, bays, etc. They retain floodwater, they restore flow, they keep streams cool, they filter pollutants before they reach downstream waters. They oftentimes are really kind of the filters and the bloodlines of our water systems. The vast majority of people who are on public water systems are on public water systems that are fed oftentimes in large part by these intermittent and ephemeral streams and the wetlands that support them. Areas like New York City, I know it's a famous example. It's probably not the best example for the court because it's liberal New York, but New York City has invested greatly in protecting the headwaters of its drinking water system, in part to avoid expensive treatment downstream. The systems, the headwater systems that are really at risk here, do provide a lot of support. And with climate change, those ecological functions are becoming all the more important. Mm-hmm. Climate change is promising to do things to our waters like increase the number of nutrients that flow in because we're going to have more intense storms, more runoff, et cetera. So that flood storage system upstream becomes all the more critical. For instance, in Hurricane Sandy, something like close to $1 billion worth of damage was estimated to be avoided due to functioning wetlands that help mitigate the impacts of those storms. We're seeing more and more expensive storms. We kind of talk about commerce and economic consequences. When we're suffering, $1 billion each year in damages from floods, the natural systems that protect us from those floods become all the more important to the communities that get flooded, to the resources that get washed out, et cetera. Climate change is also going to bring more droughts. When you've got natural systems that retain the water and the snow melt and hydrology in general during wet times, so that water is available to recharge during dry times, you can avoid some of the most critical aspects of drought. And that's very important to maintaining drinking water supplies. It's important to agricultural areas that need that water for crop production. The pollutant filtration obviously becomes very important. As does another real advantage of having that water recharge is oftentimes provides cold water. One of the big threats is cold water fisheries. We're going to see a lot of our trout streams disappear, particularly in warmer areas, with climate change, and healthy functioning headwater systems really help with that. And then there's impacts to environmental justice communities. Environmental justice communities are far more likely to have drinking water systems that have violations of drinking water standards. Tribal communities are more than twice as likely than average communities to have drinking water violations. African American communities are oftentimes much more reliant on things like sustenance fishing than other communities. Low income and BIPOC communities are oftentimes much more susceptible to flooding events and the damage that comes with flooding events. So, protecting these waters is also an environmental justice issue. So what does that kind of mean from a legal perspective? Because I think, Larry raised a lot of good questions about clarity and, where the lines are and how do you get certainty. And I think those are all valid. I actually feel that Justice Kennedy was not at all unwise with his opinion, and I know it's got some vagaries in it, but so does Justice Scalia's opinion, with terms like relatively permanent and indistinguishable that are hard to figure out. This is a science-based statute that's looking at dynamic aquatic systems where the lines aren't always clear. And not only are the lines not always clear, I live in New England. You visit the same stream in 3-month increments, or the same area in 3-month increments, you're going to see a different water body each time. And that's not just for some of your smaller streams. That's even for things like Lake Champlain. The shoreline will change. It becomes a different water body at different times. So, Justice Kennedy's look to science and to the relationship from an ecological perspective between these upstream waters and these upstream waters functioning as systems and the health of downstream navigable waters really had a kernel of wisdom there that I think tied to the ecological purpose of the act, and also put a bit of a limit in terms of waters, perhaps like the waters that we saw in Swank, that may be truly isolated and may not really have much of a tie, or at least a really faint tie, to our larger waters. I think the question there is, can the agency come in and figure that out? And I think the bigger question now that we have with Sackett is the Supreme Court, and are we going to find 5 justices on the Supreme Court that are going to give EPA the room to do that? Or are we going to have 5 members of the Supreme Court who are going to lay down probably a pretty hard and fast line that does not have a lot to do with ecology and with the goals of the Clean Water Act? And from our perspective, from NWF's perspective, that's really our biggest concern with Sackett. The Scalia test, I hate to characterize it this way, but it was a little bit of real men know waters when they see them test. And it brushed past some of the ecological goals of the act. And I think that's why you saw a really strong pushback from certainly the dissent with Justice Stevens, but the language in Justice Kennedy's opinion, even though he felt Justice Stevens gave way too much deference to the agency and essentially wrote the word navigable out of the Clean Water Act, Justice Kennedy was equally critical of the Justice Scalia test, largely because it ignored the ecological and scientific reality of the test. So what needs to happen? I mean, one, I think it's really hard to know at Sackett, and Sackett is going to be the curveball. I think EPA should continue to push ahead with a rule. I think the government will be in a better spot if it can point to a process by the EPA and the Corps that is bringing stakeholders together, is looking at the science, is building a very science-based rule, and one that seeks to clarify navigability and avoid some of the missteps in the 2015 Clean Water Rule. And some of those missteps, like Quanaut-Esley, were taken to, I think, give a level of clarity and certainty that maybe didn't pay enough attention to science. And that includes, I think, doing some of the things that EPA is doing right now, bringing the roundtables together with multiple stakeholders, building the science, listening to the science, hopefully, we can have by 2023 or 2024 a rule that's durable and comprehensive and as clear as it can be, and also one that is consistent with whatever the Supreme Court does in Sackett. And I will turn it back to Mark because I know that we want to have some discussion. But we are, I think, not at too different a place than we were, several years ago, with uncertainty at the Supreme Court and an agency that still can't quite find its way forward, but is searching.
Thank you very much, Jim. And yeah, and just listening to both of you, I've been writing down a couple of things that, in some ways, it's like a sports call-in show for me. I've got my experts here, and I've got my questions, and whatever the answers are, because until the game is played, which is actually going to be whatever EPA does, whatever the Supreme Court does, it's all we're doing is tea leaf reading. But one of the questions that really struck me is that, when you look back at the history of the Clean Water Act, and again, yes, it uses ambiguous, even multiple terms, but the Supreme Court now is focusing very much on one term, which is navigability. Although navigability is used, it says navigability for the purposes of the navigable waters for purposes of the Clean Water Act means waters of the United States, which is, it does not then go on to define. As I mentioned, Section 102 makes it very clear that the aim of the Clean Water Act is to really protect the integrity of the nation's waters, which it does not go on to define. But Larry, I think you mentioned that there was early on, at least in the congressional record, which I know literalists in Supreme Court don't like to read, but when there's multiple words, making it clear they envisioned that the Clean Water Act would go as far as the Commerce Clause would let it, which we didn't know because we find these things out jurisprudentially, and that's always part of the adventure.
Right.
And one of the things we know now, thanks to the Sporhays case from 1983, is that all these waters are charged within the Commerce Clause. If groundwater is within, I'm pretty sure that navigability is not a function outside of Mammoth Cave for groundwater. So, the reach of the Commerce Clause is pretty darn extensive here. But is the Supreme Court really trying to interpret a statute here? Or are they really trying to, do you think, read in a governance model or philosophy, where that there are just some things we don't want the federal government to do, and some of the discussion of the concurrent responsibilities and rights of the states, and because I think that's going to be a fundamental, a steering current to this. I mean, what do you think?
Well, I think that's clearly the tension. I mean, if you look at they needed 4 votes to get this, to take this case. They knew that there was a rulemaking ongoing. As Jim said, may make more sense to defer to the expert agencies and the scientific analysis to try to come up with a doable rule, but they jumped at it and tried to, and are going to be interpreting whether the significant nexus test is the appropriate test while the rulemaking process is underway. So they're not being informed by rulemaking, they're trying to get ahead of the rulemaking and try to provide advice. So I think the way I read it, given the bent of the Supreme Court and the fact that we got 6-3 conservative majority, literalists looking at language in a literal sense, is that I think there's going to be a leaning towards navigability and what it means literally, and more and less of an emphasis on the broader water quality goals of the act. And you're right. I mean, 1972 Congress, when you look at the history of the Clean Water Act, looked at it in a plenary way. Water moves in hydrologic cycles. There are broad goals in the act. In 1977, Congress there was an effort to pull back on jurisdiction, and you look at the Riverside Bayview Homes decision goes into that and said that was rejected. So clearly Congress considered it and said, we're going to retain our interpretation of a broader approach. And that is still Supreme Court law. It's been out there all this time, despite what Swank said and despite what Rapano said. But I think given the current bent of the court right now, I think there's going to be more of a leaning towards maybe Section 101B, the rights of the states, versus 101A and the broad goals of the Act. I mean, I think one of the key, as you look at this, the question is there a limiting principle? One could argue that the Commerce Clause is so broad that even groundwater would be considered a water of the US, arguably. And yet the courts and EPA have to always stay in position. It's not a water of the US. And even the Supreme Court said that, has said that. So, but one from a ecological standpoint, from sort of a unitary waters principle, could conceivably find that any part of the aquatic ecosystem is related to every other part and ultimately provide some water quality benefits to a traditional navigable water. But the court is going to be looking at, but there's got to be some reasonable limiting principle, because otherwise Congress would not have put 101B in there and the rights of states. Now, of course, the argument would be that doesn't necessarily mean that was an intent to pull back on federal jurisdiction. The flip side, of course, is a lot of more property-oriented folks will say, no, that's not true. There are limiting principles that have to be added, respected, and the states have a role in protecting water quality that are beyond federal jurisdiction. And Mark, Jim, you pointed out about New York State protecting headwaters. One could argue that is through state authority, states' concerns about headwaters. They're doing that, and that is arguably not controlled by the definition of what is the United States. And there are a lot of states, in Maryland, for example, I've done a lot of work in Maryland, Chesapeake Bay. Maryland Non-Tidal Wetlands Protection Act that I was involved in broadly regulates wetlands, regulates all activities that impact wetlands. It has a buffer requirements. It has a no net loss requirement. That's a state that says we're going to go beyond the federal approach because wetlands have to be protected. Virginia, in many ways, does the same as well. Of course, you go out west, in states like Arizona, the more conservative states, go the other way. And some states have said we're not going to regulate beyond federal jurisdiction. But that sort of begs the question of, are there limiting principles that can be discerned that might incentivize states to plug the gap of waters that are not regulated, versus do we need federal jurisdiction in a plenary sense? Otherwise, that we're going to violate not achieve the goals of the Act. And that's sort of the conundrum that I see we're all facing here as we try to get our arms around what this really means. I anticipate the court's going to come out with a more limited approach. And what is that signal is that going to be to EPA and the Corps and the states in trying to get their arms around this very complex issue? I mean, these are dynamic systems, Jim said. You were talking about trying to come up with a national definition to apply to the arid West, the coastal plain in Maryland, and the wet aquatic system in Florida. I mean, how do you come up with a rule that defines waters of the United States that covers these kinds of dynamic and changing ecosystems around the country? That's a really hard task. So I think that's the way I see it, is the court is going to come out with some kind of more limiting approach. What will that do to the rulemaking process? We obviously have to wait and see. I think the agencies are coming forward with rulemaking anyway. Would they come out with a rule before the court, comes down with its decision? Right now, they're trying to come out with a rule that restores the pre-2015 regulatory regime. Would they finalize that? And then some or other try to argue that the court should give deference to that and sack it? I mean, that's an interesting legal question. The briefing will probably be done by the time that rule comes out, but before the case is argued. But, there will be a record that will be out there on this current process that potentially the court could consider. So these are all open questions right now that I think we can't get totally our arms around, but I think they'll be have to be addressed.
Well, Jim, let me ask you a question, 'cause Larry hits a number of, I think, important points, but obviously, I mean, we're dealing with dynamic systems. We're dealing, as you noted, with systems that it's not just, is it wet? It's you get into the water chemistry, you get into the seasonality, turbidity. There are a whole bunch of things that go into protecting waters that have nothing, absolutely nothing to do with navigability. Yet they were fundamental, to what Congress had in mind when they passed the Clean Water. But if the Supreme Court comes out with a rule that pushes back the jurisdictional boundaries of the Clean Water Act, which I presume it would say these are the rules that should have always been in place, which is one of the reasons it's hard for them, to me, to reconcile some of the earlier jurisprudence. But under the auspices of two things: one, protecting states' rights, and secondly, provide greater clarity. Do you see either of those outcomes coming? I mean, will there be greater clarity of where the boundary is, or will it just be a different boundary?
I'm not sanguine about two things. I'm not sanguine about the Supreme Court not doing, frankly, some damage to the act. And I'm also not sanguine about clarity coming out of this. Even the Scalia test was not super clear. It purported to be, but I don't think it, relatively permanent is a vague term. I think the traditional navigable waters rule that the Trump administration put out, had a lot of vague terms in it. Once a typical year, that was really, hard to tell. It's going to be harder to tell as climate change changes hydrologic cycles, and all these waters start to look different than they did 10, 15 years ago. So I don't think we're going to get a lot of clarity. The couple things that give me some hope that the Supreme Court will either try not to do what conservative courts are supposedly not doing, which is legislate from the bench, is the Maui decision, which I think surprised some people.
Me.
Yeah, but I think it was a relatively functional equivalency is is a term that the agency had to figure out. But the fact that there was a majority of votes to essentially look at the purpose of the act and realize that allowing a hyper technical interpretation of discharge of a pollutant would really kind of would subvert I think what any common sense person would see as what that term was meant to achieve and what was going on factually. That gives me some hope. And Robert's hesitancy in Rapanos to indicating that if the agencies were moving, he would prefer for some technical guidance from the agency rather than the court doing that. Perhaps the court will scale back a little and write an opinion with some room for the agency to be protective on an ecological basis. That's my biggest hope for for Sackett. Does significant nexus survive? I'm not sure it does. I'm not sure it does with the interpretation Kennedy put on it. It is a term that's been around since Riverside Bayview. So I hopefully the court will not just brush it aside, for kind of the more Scalia view. I do want to address a little bit the idea of states' rights, and it'll be interesting to see how the court deals with this. When the Clean Water Act was passed, it was a very different time in America in a lot of ways. One, we had a true water water quality crisis. And I think we've got another water quality crisis, I think, slowly unfolding as more and more of our waters start to fall back into impairment. But the Cuyahoga River was famously on fire repeatedly. Lake Erie was effectively dead. We had serious water pollution problems, and one of the things that really led to that was a series of weak statutes preceding the Federal Clean Water Act of 1972 that gave a lot of deference to the states, and Congress knew that, and Congress clearly passed that statute with a much more robust role for the federal government in mind. And also, we have to remember what 1972 was like. It was we still had a lot of people from the Warren Court on the court. The Nixon appointees looked pretty liberal compared to what we've seen from some recent appointees. It was after the New Deal and the Great Society. There wasn't a lot of the federal government was pretty robust, and federal reach was pretty robust. And I think most members of Congress kind of saw it that way. Maybe they would have provided a little more clarity if they had been able to peek 50 years into the future and see who was going to be on the bench and kind of see where some of the politics in America had landed. So I think Congress intended a very broad reach. And if you look at the statute provides a really robust federal state partnership based on this broad federal jurisdiction. Almost all states administer their MPDES permits, and really administer their 401 permits. So a lot of the administration of the Clean Water Act is done by the states, with help from EPA. The states promulgate their water quality standards. EPA really just has like an oversight role in that. So, by and large, it's a state-run program with a federal partnership. And I think 101B had a lot more to do with that than trying to limit the role of the federal government and curtail this kind of federal baseline of protections. I'm not sure the court will see it that way, but I firmly believe that is what Congress was thinking about in 1972 when, as Larry mentioned earlier, and I think it's really worth noting, this act passed overriding a veto. It was very hugely supported and supported in a bipartisan fashion. To address a very real problem.
I'm going to interrupt for a quick second, Jim, and but Alex needs to make sure that every lawyer who wants CLE credit is playing by the rules. Alex, go ahead.
Hi, everyone. If you're getting CLE credit, the code word for this panel is blue. I'm going to release the poll right now. And for the panelists, I ask that you don't click the tempting end poll button that is going to come up on your screens since you are also co-host, because it will end it for everyone. It won't just X out of the box.
Okay.
We'll just who's tempted by the potential for chaos.
And we'll find out who's napping.
Yeah. Oh boy. Looks like we're 100%, Alex.
All right, I'll leave it open for a few more seconds, and then it'll close itself, but please feel free to continue.
I wanted to follow up on some, Jim was mentioning really how that, what the tenor of the Clean Water Act was about. And also, I think, when you realize that it was not just, water quality that had led the federal government into this, into this party, back in the 1890s, when they got involved with the Rivers and Harbors Act, in part because they were investing in federal infrastructure, bridges, canals, things like that. And states were screwing it up. They would, if you built a federal, a canal or something like that, and a state allowed a bridge to be put over it, which defeated the navigability purposes, you needed something. And that's really one of the reasons you had the Rivers and Harbors Act. And which also, did deal with pollution. You know, the Refuse Act was
Refuse.
actually a criminal act.
Right.
So you're right. I think we have faced a pollution crisis more than once in this country, and we faced the need to, you know, federalize water management. You know, and I'm not sure that that gets much respect anymore. I mean, I know I teach water laws, as I've said, and one of the things that always struck me that, you know, the Clean Water Act was accommodating was that state water law, which deals with who owns water, who can use it, you know, that is state law, and you owe your neighbor something with respect to water quality, irrespective of a federal scheme. I mean, and I think they're trying to make clear we're not, you know, they were not supplanting that. You know, they might create a floor, but, you know, they were not going to take away riparian rights. They were not going to take state rights away. And I think that's why, you know, water quality certification has remained primarily a state function. I've really not seen many states begging for the opportunity to regulate wetlands. You know, in fact, you know, short of, you know, until Florida, for the most part, you know, states, they love to complain about the federal government, but boy, were they glad they were there to take the heat and the budget. But since we are talking about the broader effects and reach of the Clean Water Act, I mean, it's a lot more than dredge and fill, even though dredge and fill is what drives a lot of this litigation. We do have NPDES issues, and that is what really has improved a lot of the water quality. We're going to have to do more with non-point source. That also goes to the ultimate reach of the act. And we're also dealing with, you know, mitigation. 404 requires that you avoid and compensate for the impacts you have. If we have a significant retrenchment in where the jurisdictional line of the Clean Water Act is, what do you guys have any thought of what the bigger ripples are going to be? I mean, if I bought a bunch of mitigation credits for, you know, damage to a wetland, and the Supreme Court now comes out and says that should never have been covered, do I have a taking claim?
Yeah, I guess let me just give you my thoughts. I mean, I agree with you, and certainly we're dealing with climate change issues and the dynamics, so that's obviously a big factor in all of this. But, you know, when you look at the Clean Water Act, 404 is just one important regulatory issue. Remember, you know, Sackett is dealing with 404 and a wetland. It's not really reaching these other issues. You know, Maui dealt with those other issues. But, you know, you're right that, you know, the Clean Water Act addresses a broad range of other kinds of issues and programs that in many ways are administered at the state level, you know, local level. I mean, you think about TMDLs, you know, Ollie Hack and all the work he's done on TMDL programs, and, you know, dealing with the Chesapeake Bay, you know, MS4 permits, you know, that are issued on a countywide basis, you know, because of, you know, discharges into MS4 systems that make their way into the Chesapeake Bay and meeting the Bay cleanup goals of the act. I mean, that is an important role for state and local governments and for citizens, you know, to play a role. But the question then becomes, if there's a narrower definition of waters in the United States, only limited to flowing streams, how will that undermine the ongoing effort in terms of TMDLs, in terms of non-point source pollution? Even the Maui court made it very clear that, you know, non-point source pollution is largely regulated at the state level. And even Scalia said in his opinion that you can have a non-water in the United States, it can still be a point source. And you can have an indirect discharge into that non-water, and that can be regulated under NPDES and require a permit. So the question of whether a narrow interpretation will undermine the goals of the act as a whole, I think is very much an open question. I think the issue will be how will states react if we're coming out in a more narrow interpretation? You've got a good number of states out there that regulate beyond the federal definition, you know, and certainly, you know, Maryland, Virginia, the East, New York, some of these East Coast states are doing that. Then you got a bunch of states out west that are so focused on property rights and concerned about that, that they've right now, at least for now, precluded regulating beyond the definition of what is the US. Will that in any way undermine the efforts of those states to deal with non-point source pollution concerns? You know, they can turn around and say, you know, somebody's building a shopping center, you know, in an isolated wetland where you're going to have clearly real impacts to an intermittent stream that we're flooding with climate change that'll affect a downstream water quality, but you don't need to get a permit from the state, forget it, you know, look the other way, you know, here's your, you know, just go and run and build your shopping center, you know.
None of that could happen, could it, Jim?
No, none. I think it's a really open question. I mean, I think it will and already has created a lot of confusion and some, you know, what about existing MVDS permits on streams? And even if you can treat a intermittent ephemeral stream now as a point source with an indirect discharge, who's ultimately responsible? What if the discharge is on one property and the ephemeral stream discharges into what's clearly inhabitable water on another? Whose responsibility is ultimately to, you know, to deal with that discharge? Yeah, and then, you know, you mentioned, you know, kind of building the Walmart on a wetland, and you know, if that's not regulated, what happens to that water? A lot of times that water goes to the property owner below, and you create a situation where, you know, another property owner is flooded, and there's a harm, you know, in that circumstance. You know, I think without that federal floor, you're going to see a lot more uneven administration of the Clean Water Act. And I also think you're going to, you know, it's 36 states right now that have kind of no more stringent than federal protection. So it's a lot of states right now that don't allow you to protect more stringently, and also with things like TMDLs. You know, the Chesapeake right now is a great example of a multi-state TMDL that I think has a chance of starting to bring the Bay back to health after many years of kind of nutrient pollution that, you know, that's been hammering the Bay Area. And, you know, as with a lot of waters, you know, some of the states that contribute most to the pollution problem are states that don't have to live with the Bay. It's Pennsylvania. And, you know, having that federal floor has allowed for that multi-state TMDL to come together. I think without that federal floor, it's going to make it a lot easier for, you know, some of the upstream states and complicated bases like the Ohio and the Mississippi to say, you know, for us, it's economic development. For you, it's a water quality problem. What incentive do we have to help out on this? So, you know, I think Larry's right. You know, what the states do will matter, but I think without that federal floor, it's going to be a lot harder, especially with, you know, really challenges that are deeper and I think harder to solve than a lot of the immediate cleanup that happened right after the Clean Water Act was passed. We just had, you know, a lot of cities and industries that were dumping untreated waste directly into our waters. Now we've got it's a lot of runoff, it's agriculture, it's non-point source solution, it's increased stormwater. You know, these are tougher challenges, and with a weaker Clean Water Act, they won't get any easier.
Jim, you mentioned something there with nutrients and the TMDLs, which I think is an important thing, certainly for us here in New Orleans. Obviously, you know, the condition of the Mississippi River needs to be improved a lot, and the state of Louisiana has done not very much to make its neighbors do much. But right now, nutrients are a limiting factor on how, you know, much the river can be used for like coastal restoration purposes. And Mississippi and several like fishing groups are suing the Army Corps of Engineers over the operation of flood control projects because, in part, with increasing, you know, flood control openings, partly attributable to changes in precipitation patterns, partly due to changes in the hydrology of the river, that our ability to operate essential federal infrastructure is being compromised by water quality that is not a point source.
Mhm.
And that we're finding that the only vehicle you really have for addressing this, one would be a compact. You need it, and you need something to trigger that. A direct action by Louisiana against other states, or Section 319 of the Clean Water Act. I mean, there's been as you know, an effort to, cooperatively deal with the river, but there's no hammer in the pocket at all. So I think it's interesting where that goes, and I don't think the Supreme Court's aware of that. But we're close to witching hour here, but I wanted to give you each a couple of minutes just to, give your closing thoughts, words of encouragement, whether you're booking your flight to Mars.
Want me to start?
Go ahead.
Yeah, go ahead, Larry.
Yeah. Well, I think we're facing a continued confusion that will come out of the Supreme Court opinion, because I anticipate it's going to be fairly limiting and conservative, and a potential reaction. Now, the question is, what kind of reaction will there be? Will this somehow have a somewhat of a reverse action, positive action, where, there will be a groundswell to say, look what's being lost by a narrowing interpretation. We need to work to expand state regulation, to develop data on what's being lost, the impacts, and why the Clean Water Act is being hurt by this stuff. And then with that, indeed spur more state action and more pressure. Some states may not. I mean, I think no matter what happens, there may not be a strong effort to do that. Other states may. I mean, one of the interesting things to watch is, Florida assumed the 404 program based upon the Trump definition. And I understand there's a lot of confusion there about what are federally assumed waters and what aren't. And I guess the state of Florida is saying the definition, when our assumption program was approved, is what controls. And that was the Trump definition. Whereas the environmental community, I think they're suing on, or whatever, there's a lot of litigation on that, saying no. Now that definition was vacated. And so it's whatever definition is in effect at the time is what is legally in place. And therefore, Florida has to go back, or has to apply a broader definition from the regulatory standpoint. Of course, if the Supreme Court comes out with a narrowing definition, that would support Florida's interpretation to abide by the Trump rule. So that's I think an example of where there could be immediate impact from a narrowing definition on an ongoing wetlands program, i.e. the state of Florida that assumed it, saying, hey, we've got state regulations, but we shouldn't be limited by the federal definition. So, but I think at the end of the day, maybe I tend to be somewhat of an optimist. I think even in a narrowing approach, I think you're going to see, hopefully, folks taking a broader interpretation at the state and local level around the country to deal with this issue more broadly, and to say federal-state partnership in the Clean Water Act, we have to act. We have to do something to protect these headwater areas. We have to do something to protect these isolated waters, because we're going to lose something if we don't. And so I think that's what you may see coming out of the Supreme Court.
We look forward to you running for governor in 36 states.
I can't establish residency in more.
That doesn't seem to matter so much anymore. Jim.
Yeah, I mean, I'll close on kind of a high note, and yeah, I hope the Supreme Court does not drastically limit jurisdiction, but I think we kind of, regardless of what the Supreme Court does, I think we're at a really kind of a crossroads with water quality and water systems right now. We are realizing, especially with the challenges of climate change, how important and how under stress our waters are. And I don't think, quite honestly, the complex problems we have, they're certainly not going to be solved by the Supreme Court. And I'm not sure they're going to be solved by even a very forward-looking EPA at the moment. We really need, I think, states localities, the federal government, and I think ultimately Congress to come together and really think of what does a new water quality structure look like for the 21st century, and how do we ensure that our water systems, given the stresses on them, given climate change, how do we protect them, and how do we protect them collaboratively? Slicing and dicing legal terms is, it's going to be done. It's helpful in some ways to provide guidance, but the challenges we've talked about, nutrient pollution, the thing that Louisiana is experiencing with the degradation of Mississippi, the degradation of the Chesapeake Bay, the degradation of our coasts, flooding, increased droughts, et cetera. We really need to, I think, pull together from a policy perspective and think about ways that we can build on the Clean Water Act, but also really ensure that we've got the protections in place at the state, local, and federal level that are going to help us deal with climate change and help our most precious resource, which is really water.
Well, I want to say thank you to you both. It's been, for me anyway, a very instructive panel. I hope you both consider the possibility of hiring our students as like summer and interns. I realize you've got to accommodate Vermont, but there's plenty of room here. There's plenty of room. Again, I guess time will tell. But I have a feeling we could reprise this panel, every year for the next 25 to 30 years, and it would remain fresh.
This issue is great for panels.
Yeah, well, again, it is sort of like the sports talk shows that it's
Sometimes dozes never closes, never an answer.
There you go. Well, thank you all very much. Alex, Charles, do you want to say any closing words here to our guests?
Thank you so much for being panelists today. I have learned so much, and thank you to all of our guests for coming. We really are happy to have you. So, and here.
I'm hosting.
On your screens, they're the ones who've helped make this happen. And this is a student-run affair. Nothing in their past generally prepares them for it, and there is no ample reward following it. So, but please do appreciate it, and if you get a chance, let them know. Thank you so much.
Yeah, thank you so much. It was
thank you.
good opportunity.
Really appreciate it.
Yeah, sure. Thank you. And thank you, Alex, for doing all the technical work to set it up. Really appreciate that.
Oh, happy to.
Okay.
Good.
Take care, everybody.
Yep. Have a good afternoon.
Yeah,
Bye-bye.
take care.
Great. Yeah, take care.